Okay, Mr. Glazer, I have James Dotson is logged in. Do you need to speak to him before we start?
Um, is there a prosecutor present?
Ms. Arnold is here, but I don't know if she's handling that case.
Okay.
Oops, sorry. I can't get my video to go. I can appear on it. There we go.
Could I speak with her just for a minute?
Um, yeah, it's fine with me.
Okay. Jason.
Yes.
This is file 24-21749-FH People versus Jason Lindsay. We are here today for an arraignment on an alleged probation violation. We are proceeding today by video conference. Sir, you are Jason Lindsay.
Yes, sir.
Mr. Lindsay, have you received a copy of the request and summons for probation violation?
I have not, sir. I didn't know about today's court date until my attorney notified me yesterday.
Who is your attorney?
Um, um, I was on the road when he called, so he told me his name. I just can't remember off the top of my head. The conversation was fairly brief, and I can't remember.
Okay. Sorry, give me just a moment. I'm trying to pull it up on my screen so I can show it to you.
Okay.
You two hanging out?
All right, Mr. Lindsay, I'm having an issue with my computer. I don't seem to be able to pull it up on my screen. And since you have not received a copy of the request and summons for probation violation, I am going to adjourn this hearing for another date. I'm going to adjourn this to next week on October 15th at 8:15. And in the meantime, we will mail you a copy of the request and summons for probation violation. Is your address still on Division Street in Adrian?
Yes, sir.
Okay, we will mail it to that address and you'll need to log back in next week on October 15th at 8:15 a.m.
Yes, sir. Thank you.
Right, so you're all set for today.
Okay, thank you.
Okay, Mr. Glazer, are you ready with Mr. Dotson then, or did you need to speak to him now?
No, I'm ready, Your Honor.
Okay, this is file 25-22227-FH and 25-22391-FH. People versus James Alfred Dotson. We are here today for a pretrial conference in both of those cases, and we are proceeding today by video conference. First, I have the attorneys place their appearances on the record.
John Glazer on behalf of Mr. Dotson.
Oops. Still having trouble with video. Allison Arnold on behalf of the people.
Okay, and Mr. Glazer, where do we stand with Mr. Dodson's case today?
Your Honor, I'd ask to adjourn this either like a week or two at the longest. I need to speak with Mr. Bayonetto, who's not here. He's not present, or he's not working today.
All right, so we're at 175 days on the older file, so this is going to be the last adjournment. I'll set it out for a couple weeks, but if there's no resolution at that point, it'll be set for trial.
That's fine.
And we'll go with October 22nd at 8:15. Mr. Glazer, would you do that stipulation in order?
Yeah, I can do that.
All right, Mr. Dotson, you are all set for today. Your next date will be October 22nd at 8:15 a.m.
Okay, thank you. Have a good day, Your Honor.
Thank you.
Say shit. Rolling. There you go. Close it out.
Okay, Mr. Glazer, Mr. Conway is not here. Do you know where he is?
Uh, no, but Mr. Conway's notoriously late. I saw him in person yesterday and told him there was court today, but I don't know where he's at. I can try calling him.
How about Mr. Kensner? He's not here either.
I don't represent him, Mr. Benson.
Kensner,
Oh,
Ketzner.
Ketzner. He's I think he's in prison.
He is.
All right. I don't have any MDOC logins at the moment.
Your Honor, on Richard Garreau. Gosh darn it, I don't have his files, but I sent over to Darren. Gosh darn it, I don't know, I don't have his files. Paper, he's in the hospital.
Okay, let me
And
call.
Yeah. And
Here.
I'm,
Hang on, Mr. Glade.
oh, there's Darren.
All right, so these are files 22-20936-FH, 25-22330-FH, and 25-22331-FH, People versus Richard James Garrow Jr. We are here today for 22 case has a probation violation pending. The 25 cases were set for pretrials. There's also pending contempts in those cases. First name of the attorney's placed their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
John Glazier on behalf of Mr. I don't know how you say it. It's Garreau or Garreau, or Giroux, maybe.
All right, so Mr. Glazer, you were saying off record that Mr. Garrow is in the hospital, and I believe we do have some communication, or Mr. Coast has had some communication and been able
Yeah.
to that.
Yeah, he had a pretrial yesterday in district court, and when I called, I talked to his girlfriend or fiance, I'm not sure which, and she said I know he has serious heart trouble, and he's in the hospital, and she sent me paperwork to show that. I sent that to Mr. Coast. I also sent to Mr. Coast. I'd finally gotten his list of drugs that he takes, and 3 of the drugs that he takes would test positive, show false positives on a drug test, they said. And so I sent all that to Mr. Coast, but Mr. Giroux, I assume, is still in the hospital.
Judge, I did speak with his significant other. He is still in Henry Ford Hospital. I have documentation that he was there. He went in on the 2nd. He was there on the 3rd, and his significant other said that, yep, he is there, and that was yesterday. As far as the medications, I did cross-check all the medications submitted. I don't see any of them that were a amphetamine, so.
Yeah, they're not amphetamines, but they can test positive. They can have false positives for methamphetamine.
Okay, so he's been testing positive for methamphetamine and ecstasy. So which of those drugs are the ones that make him test a false positive for
Well,
those?
ecstasy is the same as amphetamine. It's a speed. But the drugs he takes would test positive for amphetamines, which would be methamphetamine. It would also be ecstasy.
Okay, so which ones?
Oh, Darren's got him. I sent him to him. He takes about 10 different drugs.
Judge, I have 11. I have 11 medications, and none of them show that they're an amphetamine. So I don't know which one would show a false positive. But here on out, if you'd like, what we could do is we could do swabs where we actually send it to the lab, where they could break it down to say if it is meth or if it's a different medication.
All right, why don't we proceed that way then?
Okay.
Yeah, and again, I don't know whether a swab would test positive or not. All I've looked up is I looked up the 3 drugs that I sent to Darren. I don't have my file with me. Darren has copies of them, and all 3 of them say that those drugs will show positives for amphetamines and I don't know whether a swab, urine, or blood. One of them even said a blood test would show positive, I believe.
Judge, the lab that I use they could actually tell if it's a medication or if it's actually the components of meth. So I don't think there'd be a problem if I did the swabs.
All right, so we're going to proceed with swabs from here forward, and we'll see what happens with that. Ms. McClure, is there anything that you wanted to add with respect to Mr. Garrow?
Just that he did have a bench warrant entered yesterday in district court for failing to appear, so I don't know how this court wants to proceed, if it's going to just adjourn out or,
They withdrew that, Phoebe.
okay.
I sent
Well, either
over.
way, I just, I guess if we're getting another pretrial date, I want to make sure we have a way of actually getting a hold of him to get him notice of his next pretrial.
Do we have an understanding of when he might be released from the hospital?
I didn't get a feeling. It sounded like it was a heart procedure that was done, but I have no idea.
Judge, it was a heart catheterization. So I have been in contact with, I believe it's his wife. So I'll check back with her either today or tomorrow.
So I guess I would request that whatever pretrial we get next, if we could give the notice to Mr. Coase so that next time he makes contact with Mr. Giroux, that he gives him the notice.
I'll send out a letter as well, Aaron.
Okay, so I'm going to set it then for November 5th at 8:15. And I think for this one, the court will send out the notices, and Mr. Glazer, if you would send him a letter as well. Okay, is there anything else we need to address with Mr. Garrow?
No, Your Honor.
Nothing on behalf of the people.
Okay, thank you. Yes. Okay, this file 25-22364-FH, People versus Jonathan Tucker Ketzner. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Oh, I'm sorry, it looks like Ms. Glazer's on the phone. All right, Mr. Glazer, I just called Mr. Ketzner's case. Do you want to place your appearance on the record?
John Glazer on behalf of Mr. Kessner.
Okay, and Mr. Ketzner is currently in an MDOC facility. I don't have any MDOC facility logged in at this point.
Okay.
I don't see any confirmation in the file that they were contacted or notified of his next hearing. So I think the only thing we can do is adjourn this to another date at this point.
That's fine.
Unless either Ms. Arnold or Mr. Glazer has anything that needs to be addressed today that we can address without his presence.
I don't believe so, Your Honor.
No, there's nothing we can do without him here, Aaron.
Okay. So let's set this then again for November 5th at 8:15, and we'll make arrangements to have him present by Zoom on that day. And then Mr. Blazer, Mr. Conway is here in the courtroom. Are you going to need to speak to him?
Yeah, just for a moment, Your Honor.
All right, Mr. Conway, if you'll step outside, there's an iPad right outside the door, and we'll get you set up in a breakout session on that. Okay.
How you doing, Ernest?
Judge, Ernest Conway has not been testing, so I do need to see him today.
Okay. Mr. Dagner, go to your hand today. Yes. Okay, this is file 24-21979-FH, People versus Paul Anthony Gargan Jr. We are here today for a hearing on a alleged probation violation. We're proceeding today, partially in person, partially by video conference. Mr. Dagger Margosian, would you like to place your appearance on the record?
Your Honor, good morning. Michael Dagger Margosian for Mr. Gargan.
And where do we stand with Mr. Gargan's situation at the moment?
Your Honor, I am covering for Ms. Underwood. However, in reviewing the documents and the VOP paperwork on this, it looks like the alleged violation is for Mr. Gargan not paying the monthly payments for the restitution. I spoke with him yesterday, and my understanding is that he is in a position to put down a large chunk of the payment based on prior 401k investment type situation. I think what would be appropriate would be to adjourn the violation of probation. He's still on probation for another 1.5 years. So I think the violation of probation allegation is premature anyway, but in the event that it's not, I think it still makes sense to just adjourn it and allow Mr. Gargan to make payments. My understanding is he's been in compliance with all other conditions, so that is my request at this time.
Okay, my frustration here is that this, and I understand you're covering from Ms. Underwood, but I think it's important for this to be heard. My frustration here is that this was something that was supposed to happen immediately or very soon upon being placed on probation, at least some kind of significant payment. And no payments at all have been made, which is my understanding. And so we have this probation violation that's been pending since July now. And each time we come back here, I've heard he's about to make a payment, he's about to make a payment, and still no payment. And so that is my frustration with this case. Something needs to happen soon, or I'm going to schedule it for a hearing and we'll just make a determination on whether he can make payments and isn't, or if he's in violation for just not complying with the provision that he make payments toward this restitution. This was an embezzlement case, and so the whole point of the probation is to get the restitution paid, to get the money taken paid back. And so I believe I've been patient to this point, and the patience is running out. So, Mr. Gargan, something needs to happen, or we're just going to set it for a hearing, and we'll have evidence, and I'll make a decision on what's happening and whether it's a violation or not. So. I will adjourn this out to November 12th at 8:15 a.m. And I think you can expect that if we are in the same situation that we are today, that it would be set for a trial at that point. So, Mr. Gargan, you can go ahead and log out. Your next date is November 12th at 8:15 a.m. and you'll log back in with all the same Zoom information that you used today. I don't know whose device that is, but it needs to be shut off. Okay, and then Mr. Dagan-Margosian, I'm sorry, who else did you have this name?
Miss Lane, Melanie Lane.
Okay, we can call that. Ms. Lehman, you can come forward, please. This is file 25-52956-PH. Kathy Ann Winslow versus Melanie Lehman. We are here today for a hearing on probation, on a personal protection order, alleged personal protection order violation. We are proceeding today in person. Mr. Dagan-Margosian, do you want to place your appearance on the record?
Your Honor, good morning. Mike Dagan-Margosian for Miss Lehman.
Okay, and Mr. Dagan-Margosian, where do we stand with this case today? I believe there are actually two pending contempts. There was one previously, is that right? Let me look. Yes, there's one from September 11, 2025, and one from October 4th, 2025. She has been arraigned on both, and I think both are set for hearing this morning. Where do we stand, Mr. Dagan-Margosian?
I think only one is set for today, but if not, it doesn't really change anything.
I know the more recent one is set for today. I thought that the older one had also been set for today, but I'm not entirely certain on
Okay.
that. But
Regardless, Your Honor, I am covering for Ms. Underwood. I reviewed the file, and in speaking with Ms. Lehman this morning, my understanding is that the PPO, the underlying PPO, which is really the origin of both of the alleged violations, there is a hearing to, Ms. Lehman is asking the court to terminate that PPO, and I believe that hearing is set for 10/15 next week. So I think so if that's true, I think what would make sense would be to place both show causes or contempts from the PPO, place both of those on the same day, and Ms. Underwood can deal with those depending on what the outcome of that PPO termination hearing is. And I think Ms. Zilke from our office covered one of the violations, and that was set for 10/15 as well.
sorry. Let's see. I know we set an evidentiary hearing on the motion to terminate in our system. Time that was sent for it could be the Ms. Clark, do you have in our book what date the evidentiary hearing on this Wilzer versus Lehman PPO hearing is set for?
Checking the book right now, Judge.
Thank you.
All I have in the book, Judge, is for October 15th.
Okay. Okay, actually, so the motion to terminate was given an original hearing of this morning at 8:15. So we have not set an evidentiary hearing on that. Is there Ms. Wilzer present?
Yes, I am.
Okay. Ms. Wilzer, can you come forward and sit at the table here closer to the television? Okay, so Ms. Wilzer, have you received a copy of that motion to terminate the personal protection order?
I saw, they brought something that had 5 pages of lies that she had told, but I don't recall that it was a termination of the PPO.
How did you know to be here today?
What, hon?
How did you know to be here today?
Because I had brought 40 pages of stuff up that was taken off of phones as
Okay,
proof.
I need you to slow down, okay?
They told me.
Can you listen to me for a moment?
Sure.
We are not at the point where we're going to argue back and forth about whether I should terminate it or not terminate it. I just want to know whether you got a copy of her request asking to terminate the PPO.
I'm not sure if I did or not, but they informed me at the office Monday that it was still set for today.
Am I correct in presuming that you are not in agreement with terminating the personal protection order?
No, Your Honor, I'm not.
All right. So we're going to have an evidentiary hearing on that motion because the original petition and the motion to terminate contain conflicting factual allegations. So Ms. Clark, I'll need a evidentiary hearing date for the motion to terminate.
Friday, October 31st at 1:30.
Okay, and just so the parties involved are clear, when it comes to the motion to terminate, my decision whether or not the PPO should remain in place, you are not entitled to attorneys to represent you in that hearing. When it comes to the alleged violations, Ms. Wilzer, if you don't have a private attorney representing you, the Lenawee County Prosecutor's Office would represent you. And Ms. Lehman, you are entitled to a public defender, which you already have, to represent you with respect to the violations. So you're entitled to representation with respect to the violation issues. You're not entitled to representation with respect to the motion to terminate. That's so we're going to set an evidentiary hearing for October 31st at 1:30 p.m. We also had, I think Mr. Dagenham goes that you were correct. One of the violations was set for today, but the other was not. What I'm going to do is I'm going to set pretrials on the violations for October 31st at 1:30 p.m. also. I wouldn't expect to move forward on those at that time because obviously I think resolution of this issue comes first, and we will then schedule, if necessary, hearings on the violations at the end of the October 31st evidentiary hearing on the motion to terminate.
So just to be clear, both alleged violations are now on October 31st.
Correct. So I know you've received notices about appearing here next Wednesday. You can disregard that. We're not going to have any hearing next Wednesday. Everything's going to be dealt with on October 31st at 1:30 p.m.
Thank you.
Okay, so you are all set then. You know where Mr. Conning is?
He's in the hallway here because he can't turn off his phone. There he is.
Okay, this is file 25-22376-FH 25-22417-FH, and 25-22418-FH. The 22376 file is set for a pretrial. 22417 file and the 22418 file are set for arraignment, and the 22417 file has a pending contempt while the case was still in district court. So first, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
E.B. McClure, map the people.
Is this Mr. Conway's case you just called, Your Honor?
Yes, it is.
Yeah, John Glazier on behalf of Mr. Conway.
All right, and Mr. Conway is present here in the courtroom. So Mr. Glazier, with respect to the 22417 and 22418 files, does Mr. Conway wish to have the information read?
No, Your Honor, we'd waive the reading of those and acknowledge receipt of the witness list, prosecutor's request for discovery. He's going to
And how-
enter not guilty on those charges, Your Honor.
Okay. So I'll enter not guilty pleas for Mr. Conway in the two arraignment files and set
Your Honor,
a-
could I ask, Mr. Conway's got a number of files. The two that he's being arraigned on are what charges?
So the arraignment files, one is domestic violence and one is possession of controlled substance.
Is that cocaine?
The controlled substance is an analog.
Okay. All right. Yeah, Your Honor, we'd ask for a pretrial to be set up. Mr. Conway needs to come in and see me. He has, I think, 3 felony files and several district court files, and I'm trying to work out something on them all, but I need to see him in person in my office.
All right, so I'll set a pretrial for let's go with October 29th at 8:15 a.m. Mr. Conway, between now and then, you need to contact Mr. Glazer's office and make an appointment, go in and see him, okay?
Yes, sir.
All right, the other issue I have is a communication from Mr. Coast that indicates that Mr. Conway has not set up his 2 times weekly drug testing and hasn't been drug testing since the case was bound over, which was back on August 13th. So Mr. Conway, you need to wait in the hallway. Mr. Coast is going to come out and meet with you to get that set up, and I'd also like to have you test today. Okay. All right.
Very good. Thank you, Judge.
Thank you.
All right, thank you, and that's all I have with you this morning.
Thank you, Mr. Glazer.
Oh, Your Honor, I had one question. Did Taisha West, did you got a waiver on that, didn't you?
I got that, yeah.
Okay, all right, thank you, Your Honor.
Thank you.
Well, where do I wait it? Right
Just
here?
on the bench across the hall from the door, yeah. Just
Okay, thank you.
right outside is fine. He'll be out in just a moment.
Thank you.
Would you call for Stephen Maples, please?
Judge, Have we seen anybody on Enrique Castillo or Mr. Castillo?
I have Mr. Castillo here. I do not have Mr. Mawad logged in. I was just gonna have someone try to get in touch with him.
Oh, no, I'm here, Judge. I'm here.
I'm sorry, you are there.
Yep, sorry. I should have spoke up earlier. I was just listening to all the good lawyers and all your good services there. But no, I've been on. That's okay, Judge. It's fine.
I apologize. Sometimes when the cameras are off, I've got too many things on my screen to.
I'm not worried about it, Judge. Absolutely not. Not at all.
Do you need to speak to Mr. Castillo or are you ready?
We're ready, Judge. He's got about just preliminarily, he's got about $8,000 to pay. He's having some hard times. I'm not sure which attorney general is on, but I wanted to see if they wanted to do any type of plea with a 771.1 factor or a misdemeanor plea, but I'm just giving the court an update, but you can call it, Judge. It's fine.
Okay. All right. So this is file 25-22269-FH People versus Enrique Manuel Castillo. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Berta.
Good morning, Your Honor. Christy Berta from the Attorney General's Office for the People.
Your Honor, good morning, Ms. Berta. Good morning. Elias Muad appearing on behalf of Mr. Castillo.
Okay, and Mr. Muad, where do we stand with Mr. Castillo's case today? You did provide a brief update off record, but what do you want to say for the record?
Judge, the matter was adjourned from the last time to allow him to see what he could do to try to come up with money on the remaining balance. He did pay the child support off, and that money's been moved, I believe, and I hope to the friend of the court for payment. He's having a hard time. I mean, he's been pretty good client, very honest, and I'm not sure how the Assistant Attorney General's office or Attorney General's office wants to proceed. We'd like to see if we can finish it today somehow, but I'll do whatever makes sense for everybody.
Your Honor, this is not an arrears only case. It is still charging at $851 per month. The arrearage as of October 6th is $10,820.04. In the entire life of the support case, underlying support case, there have been 4 payments, including the bond payment, which understandably was very large in July, but there's been a single payment of $105 paid after that. So at this point, we're not prepared to enter into a delay without some more good faith efforts to pay the support that's even owed.
That's fair. Judge, if I can ask my client, Mr. Castillo, we had a talk this morning. If the judge at some point in time has to move this case along to some conclusion, if the judge gives you any more time, you think you could make a concerted effort to pay some of that $10,000 down, or what are your thoughts?
Yes, I definitely can. It's just been a little rough lately. I came into some financial issues with my car, as well as the business that I'm running. We're about to go under, so I haven't been able to actually gain any funds. Now my business is moving in the right direction, so I'm starting to get into profitability to where I can actually be able to pay my child support.
I'll leave up whatever the Ms. Berta wants to do in the court. If you wanted to give him more time, that'd be great. But I'll leave that up to both of you as to what you would like to do.
Your Honor, given the abysmal payment history, I'm not prepared to do anything today. If the court wants to bump it and give him another shot, I'll leave it to the court's discretion.
All right, so this case was bound over in May. It has been pending for quite some time, and as Ms. Berta has pointed out, the payment record is not good. And so at this point, what I'll be willing to do is provide one more adjournment, but there's got to be a payment between now and then. It's got to be at least in the amount of the monthly charge, and it ought to include some payment down of the arrearage, because I just can't simply continue to let this linger and let the problem continue to get worse. So what I'll-
That's fair, Judge. What you said, I agree with, obviously, and with the Attorney General, and Mr. Castillo has been a good client, but one more adjournment, and I'll make sure that I stay on him a little bit more and see what he can do.
So what I'll do is adjourn it to November 5th at 8:15. If we're in the same situation at that point, I would be setting it for trial.
Okay.
Thank you, Your Honor.
Do you want a stipulated order, Judge, or what would you like?
I guess the people haven't necessarily agreed, so I guess the court will send out the notice.
Thank you, Your Honor.
Thank you, Ms. Berta. Appreciate you. Thank you. All right. Bye, everybody.
Judge, I did test on Mr. Conway. He was negative. So we did set up 2 times a week drug testing here at the courthouse at 8 a.m.
Okay, thank you. Mr. Noe, were you done with your breakout session or do you need to be put back in that? Mr. Noe, are you there?
Sorry, Judge, I'm having some technical issues on my end. I apologize. So I just logged out on my phone. If I could please be put back in my breakout session with Mr. Maples, please.
Yes, 1 second.
Thank you, sir.
Hold on one moment, Mr. Maples. I'm trying to get you back to that breakout room with Mr. Noe.
I think I'm here. There, I'm not here yet.
All right, Mr. Noe, are you ready to proceed with Mr. Maples?
I am, thank you.
This is file 23-21397-FC, People versus Stephen Maples. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Honor Charles Noe on behalf of Mr. Maples.
All right, so where do things stand today then?
Thank you, Judge. Where things stand right now is I've been working with the expert witness that we've retained regarding our defense. Mr. Maples signed some releases of information for him. That's a work in progress. I am keeping in touch with him, keeping in contact with him. I don't have a set time for him to have this report done or have that report to review. Certainly for Ms. Arnold to be able to review that, and if she needed her own forensic experts to look at that, that's also understandable. So what we'd be asking for, Judge, is that is still a work in progress. I spoke to Ms. Arnold previously about this matter, about today's hearing. My understanding is they have no objection to, we can set, I think it's not a bad idea to set a 30-day adjournment in this of the pretrial. We can go further if the court or Ms. Arnold feels otherwise, but I'm thinking sometime in mid-November makes the most sense. Something like that, either November 19th or maybe the 5th, unless that's too soon. But I'm thinking the 19th, and then we can maybe hopefully have an update for then, but for that by then, if not completed, and then at that point set a trial date, another pre-trial date, depending on what Ms. Arnold needs to do with that report.
Ms. Arnold?
That sounds fine, Judge.
I guess my concern with that is that this is a 2023 case, and it has been since February of 2025 that you've been trying to get a report from an expert on this issue. And I don't feel like I can continue to indefinitely adjourn the case for something that has, we've said has been coming for 8 or 9 months now on the hope that it's going to come at some point in the future. I need there to be some end to this, or some known time frame for this, rather than continue to just kick it out and kick it out. Again, this case is, since Bindo, it was bound over more than 2 years ago. So there was a district court proceedings before that. And I appreciate the desire to obtain evidence for the defense, but we can't continue as this has gone for the last 8 months or so of just saying, well, we hope we have it next time. So I don't know if that means contacting the expert and making sure this is on that person's front burner, or what needs to happen, but something needs to happen to move this case forward, because it has been stagnating for an extended period of time.
Amen.
I'm also concerned with the court's trial schedule for at least the first part of next year, that if we want a trial date at any point during the first 6 or 7 months of next year, it probably needs to be scheduled now. Because if we wait another 3, 4 or more months, we're going to be looking at this time next year for a trial. And that's not acceptable to me. So I'm sorry, go ahead, Mr. Noe.
I certainly I appreciate the court's um, thoughts on this, and I certainly would like to have it. I agree as soon as possible. If anyone's prejudiced in this, most is my client. Um, so I certainly agree 100%. And I certainly I said I certainly will make sure that this, all as much as I can, make sure the urgency is sent to my expert. And also in terms of this trial schedule, I certainly agree that this court schedule does fill up rather quickly and does get very tight very quickly. So I understand that. So I guess my inclination would be to set, if we need to set a trial date, that's fine. But ultimately to set ultimately another pretrial, just to keep our thumb on the situation to make sure that it is moving correctly, that it is moving in the right direction. Um, I guess I guess I would be fine with saying the trial date, but I'd also encourage another pretrial date in the next 30 to 40 days. There's no reason we can't do both.
So we had previously had this set for a 4-day trial. Is that still what you're thinking?
I believe that would be adequate. It's hard for me to know exactly because I don't have Mr. Noe's expert report and I don't know. I mean, I don't think that's going to add a significant amount of time to the trial, so I believe that would be adequate. Maybe we want to do 5 days just to make sure.
I think that would probably be the safer route. So Ms. Clark, what would be our first available 5-day jury trial date?
It looks like the first 5 days would be Monday, April 13th that week. However, if the trial goes over, you are starting your Washtenaw County trials the following week.
I think we can finish in 5 days. Because it might be that if the nature of the defense is some sort of mental impairment or lack of intent, maybe there'll be a stipulation on some of the facts, or some of the facts won't really be contested. So I think 5 days will do it.
What day, Ms. McGrain, does the Washtenaw County case start?
Following Monday, the 20th.
And that goes through, I'm sorry, what day?
So that one goes through Friday, May 1st, and then you start up the other defendant May 4th, and that goes through May 15th. And then you have vacation and the holiday.
All right, so are all those Mondays gone during the Washtenaw County trials? Because I don't really think I can go a month without having a Monday civil docket.
Yes, it looks like that was how that was scheduled. So we could reschedule the second defendant to give a gap between the two trials.
Yeah, we're gonna have to do something there. I can't skip that many Mondays in a row.
Well, so if we did that, you could start on Tuesday, May 5th. You go Tuesday, Wednesday, Thursday, Friday, and then either Monday or Tuesday at your pleasure for this trial.
Judge, my daughter is going to be graduating from vet school, and we are heading to Louisiana. I'm trying to remember the dates. I think it's the 11th or 12th that we leave, and we're gone through the following week, I believe. I'd have to double check the dates.
So our next set of 5 days after that, where we actually have 5 consecutive days, would be starting Monday, June 22nd.
Let me, Judge, if we can pass it for a minute, I can try to confirm those dates. Because I honestly don't remember exactly when we're leaving. I can't remember. I think the graduation is the 16th, but if the court can give me a minute, I can try to verify.
Right. I think what I'd prefer to do is use that week of April 13th, and then Sierra, we can talk with the folks maybe in Washtenaw County and see if we can make some changes to those, because I don't.
Yeah, I think, like I said, I think if the defense is going to be lack of mental capacity, there might be a stipulation to things like, that there was in fact a shooting and that Mr. Maples did in fact kill his wife. So if some of those items end up being not contested, it might shorten up the trial. But even so, I think 5 days is going to do it.
Yeah, I think the 4 days was set even without any sort of stipulation like that. And obviously, not that I'm conceding that there would be any sort of stipulation like that or any sort of agreement on that. But I think the 5 days should be sufficient as well.
All right, so let's go with the April 13th, the week of April 13th, so the 13th through the 17th. And let's go with the final pretrial on April 1st. And then, Mr. Noy, if you wanted a pretrial about 45 days out, we'd be looking at the middle of November. We could do November.
I'm not available the 12th, but I can do the 19th.
I'm sorry, what was that?
I'm not available on the 12th, but I can do the 19th.
Right, we can do the 19th. Okay, the court will issue a scheduling order then with those dates. Is there anything else that we need to address today?
No, thank you.
No, thanks, Judge.
All right, Mr. Maples, you can let the, I'm sorry. You can let the officer know that you're done with court for today, Mr. Maples.
Thank you.
Thank you.
Judge, can I check? Just trying to see where we at, excuse me, where we're at on that docket. Think that I'm caught up. Believe we have Michael Browder. Is that
Yeah.
correct? Okay. Dewan Harris.
Yep.
Kareem Henry.
Yep.
Tyler James. Dawn McCarley.
Yes.
Bradley Rohrback.
Yep.
And Dustin Smith.
Yeah.
Okay. Thank you.
You're welcome. And those are all Mr. Malaro cases, so as soon as he's here, we'll do those.
Okay. Thank you.
For Mr. Browder. Good morning, Mr. Malaro. I do have Ms. McCarley here. Do you need to speak to her?
I do, Judge, because I don't have her on my schedule, but
Okay, and also just to give you a heads up, Tyler James had been logged in for most of the morning, but I don't see him in my Zoom session now.
okay.
I will put you in a breakout session with Ms. McCarley if you give me just a second.
Hello.
Good morning, Ms. McCarley. I'm going to put you in a breakout session with Mr. Malaro if you give me just a moment.
Okay, thank you.
Thank you, Judge.
You're welcome. And Mr. Hartung, what case are you here for today?
With Mr. Malaro on Dewan Harris, Your Honor.
Okay. Let me see if they got another room. Yes. Okay, sir, you're Mr. Browder?
Yes, sir.
All right, your attorney, Mr. Malero, is working with another client right now. As soon as he's done with that case, I'll have him speak to you and we'll get started on yours.
Yes, sir. Thank you.
This is file 25-22378-FH, People of the State of Michigan versus Dawn Marie McCarley. We are here today for a pretrial conference. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, map of the people.
Salvatore Malero on behalf of Miss McCarley.
All right, and Mr. Malero, where do we stand with Ms. McCarley's case?
Your Honor, Ms. McCarley is currently at Dawn Farms in treatment center.
Malero, are you there? Okay, Mr. Malero's having a technology
yesterday
issue.
that I need to review with her.
I'm sorry, Mr. Malero, you were having a technology issue. You froze up and I was not able, I didn't catch much of what you said.
Well, I think it's IT, Judge. There's no reason they do not like me. I don't know why. So, Judge, Miss McCarley is in a treatment facility. She says she's doing pretty well, even though it's rough, which makes sense. I'd ask to adjourn this matter to see how she does there and for me to review and see if we can revise the plea offer that I think I received it yesterday from Miss Arnold. That would be my request.
Okay. Ms. McClure, is there anything to add from the people's side?
No, Your Honor, the people have no objection.
Okay, and I do have a note from Mr. Coast that indicates that he agrees things seem to be going well, I think.
Yeah, Judge, this is one where she actually voluntarily put herself into treatment and elected to stay for long term. So yeah, she's doing good.
Okay. And I'm sorry, Mr. Miller, did you say how far out you wanted to look? He froze up again. Mr. Malero, are you there? All right, we'll give that a minute to see if it resolves itself. Again, we'll see if this helps. Okay, Mr. Malero, I think we have you back now.
Judge, I swear I didn't touch anything.
If it's any solace, Charles Noe was having the same issue today. So
That's a little bit of solace, yes.
how far out did you say you wanted to go?
Judge, maybe 30 days, I think. See how she's doing.
Okay, so I can do November 12th at 8:15.
Yeah, that should work.
And could you do a stipulation in order for that adjournment?
Yes.
Okay, so November 12th at 8:15. Ms. McCarley, I think you're all set for today.
Thank you, Judge.
Thank you. And Mr. Malero, did you need to speak to Mr. Browder?
Yeah.
Okay, 1 second.
Thank you, Judge.
Sam, am I good?
Yeah, you can go ahead and log out, Ms. McCarley.
Okay, thank you.
Okay, this is file 25-22414-FH, People of State of Michigan versus Deshaun Browder. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people. Salvatore Malero on behalf of Michael Deshaun Browder, Your Honor.
All right, and does Mr. Browder wish to have the information read this morning?
Judge, at this time, we would waive reading of the information. Where did it go? Just left me.
We can still
We'd waive reading of the information, Judge, waive any defects of the time and place of service on the information. Mr. Browder would plead not guilty to counts 1, 2, 3 of the information and ask that a pretrial be set if the court could indulge us in 2 weeks. And I think maybe Mr. McCready and I can come to a resolution.
Okay, so 2 weeks from today would be October 22nd. So we'll set it for October 22nd at 8:15 a.m. And the court will enter not, sorry, the court will enter not guilty pleas for Mr. Browder and set it for that free trial.
Great. Thank you, Judge.
Okay, Mr. Browder, you can let the officer with you know that you're done with court for today.
Thank you, Judge.
Thank you. DeWan Harris. All right, and we are calling for DeWan Harris right now.
Okay, Judge.
I need to come get in touch with him.
Are you going to need a breakout with him?
DeWan Harris.
I talked to him yesterday. I hope not.
Okay.
Yeah. Thank you. Bye.
Just got notice that canceled the varsity game Friday.
Oh.
I might still take the day off.
Okay, Mr. Harris, I'm going to put you in a breakout session with Mr. Oh, I'm sorry, no, Mr. Millar said he didn't need one. So as soon as Mr. Millar gets his camera turned back on and ready to go, we'll start your case.
Okay.
All right, so this is file 25-22314-FH. That is set for a pretrial hearing this morning, also has a pending contempt report, also file 25-22371-FH is set for a pretrial conference. First, can I have the attorneys placed their appearance on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Good morning. Doug Hartung, appearing for the people today.
Salvatore Malero on behalf of Dewan Harris.
And Mr. Malero, where do we stand with Mr. Harris's case today?
Judge, Mr. Harris has been charged with some additional charges in the district court that are pending, so I'd ask to adjourn these matters. I think we scheduled the court scheduled over our objection and exam in sometime in November. So I think it's going to need to be adjourned at least past that date. I can't remember the date.
November 21st, Sam.
All right, yeah.
November 21st,
So maybe December 3rd would be the theoretical arraignment date.
okay. Do you want to use December 3rd, Mr. Malero, or do you want to go sooner than that?
Yeah, if we could go like sometime after the 21st. Well, I don't know. It doesn't. Let's see. The next week would be.
The next week is Thanksgiving, so it's the 19th or the 3rd.
I guess, yeah, let's do the 3rd, Judge.
Judge, you have the morning blocked out for a meeting on December 3rd?
I guess we're doing the 19th then.
Man, can I talk? Can we?
All right, so yeah, we can do the 19th, and if you do have the exam in district court and it gets bound over, you'd still have the arraignment likely on the 3rd. That would just be with Judge Ansel, because I wouldn't be here that day.
Okay.
All right, and I'm sorry, Mr. Harris, you would indicate you want to say something. Do you want to speak to Mr. Malero?
Yeah, I would have liked, yeah, absolutely.
Call now, see if they have another room for Mr. Henry.
Hello, Kelly and Judge Joseph. Do you have another room available? No, for someone else. Okay, could we have Kareem Henry? Could we have Kareem Henry? Thank you. All right, bye.
This one is over.
All right, Mr. Henry, your attorney is working with another client right now. As soon as he's done with that case, we will get to yours.
Okay, thank you, Your Honor.
You're welcome.
Judge, I have to leave, so Agent Moore is going to take over the rest of the arraignments for me.
Okay, thank you.
Thank you.
All right, Mr. Malero, is there anything else we need to address on the record today?
Not at this time, Judge.
All right, Mr. Harris, you can let the officer with you know that you're done with court for today.
Yes, before I go, I just wanted to get those dates.
So, Mr. Hartung, I think you had the district court date. I don't recall what that was.
The district court preliminary examination date is is November 21st at, I believe, 1 o'clock in the afternoon.
Okay, and your next pretrial in this case was December 3rd at 8:15.
Judge, I thought it was the 19th of November.
Yeah, we moved it back to the 19th.
I'm sorry, I misspoke. Yeah, so November 19th at 8:15.
And what's on the 21st?
Sam, you want to address that?
21st is your preliminary exam in district court, Mr. Harris.
Okay, all right.
Okay, so you're all set then.
All right, thanks, sir.
Mr. Malero, do you need to speak to Mr. Henry?
Yeah, Judge, I spoke with him at the jail a while back, and I think things may have changed, but I need to find out.
Okay. Okay, this is file 25-22326-FH People versus Jamal Muhammad Henry, Kareem Jamal Muhammad Henry. We are proceeding today by video conference, and we're here today for a pretrial conference. First, can I have the attorneys place their appearances on record, beginning with Ms. McClure?
BB McClure, on behalf of the people.
Salvatore Malero on behalf of Kareem Henry.
And Mr. Malero, where are we with Mr. Henry's case?
Judge, I'm going to ask to adjourn this 1 week. The reason is this, Mr. Bayonetto and I have been going back and forth. He'd made a offer that's not in the file. When I talked to Mr. Henry a couple of weeks ago, Mr. Henry was not willing to accept that offer, but now he's reconsidered. I think if Mr. Bayonetto comes back on Friday, I think we can maybe get this wrapped up even before next week. So that's the reason for my request.
Okay, so next week will be October 15th at 8:15. We can adjourn it to that date.
That'd be great,
And
Judge.
Mr. Miller, will you do the stipulation in order?
Yes, I will. And Judge, just to clarify, if we get this worked out before that date, you would be willing to take a plea?
Yeah, you're welcome to call, and we can squeeze that in whenever we have a few minutes.
Great. Thank you, Your Honor.
Okay. All right, so Mr. Henry, you can let the officer with you know that you're done with court for today.
Okay, thank you, Your Honor.
You're welcome. And Mr. Blair, do you need to speak to Tyler James?
Yeah.
Yes, I'm here.
Okay, one moment, Mr. James. I'm going to put you in a breakout session with Mr. Malero so you can speak to him privately for a couple minutes.
Okay.
Bradley Rohrbach.
You and Mr. Smith are going to.
Yeah, they may as well put them both.
Judge Ellsworth, could we have Bradley Warback in a room and then have Dustin Smith in another room for Judge Ellsworth, please? Yes. Thank you. All right, bye.
is file 25-22329-FH, People of the State of Michigan versus Tyler Paul James. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people. Sorry, I'm having similar delay issues this morning.
Salvatore Malero on behalf of Tyler James.
All right, Mr. James is here by video conference as well. Mr. Malero, where do we stand with Mr. James' case today?
Judge, I thought we were getting this matter resolved, but we've had some glitches. I'd asked to adjourn this, and I think this is Mr. Sneed's case. See if we can't get this resolved by the next court date.
Okay, what I'll do is adjourn that then to October 29th at 8:15 a.m.
All right, thank you, Judge.
And Mr. Blair, would you do that step in order, please?
Yes, I will.
Okay, so Mr. James, your next date is October 29th at 8:15. You'll log in using all the same Zoom information you used today.
Okay.
You can go ahead and log out.
All righty. Thank you.
Okay, and the gentleman at the jail, you are Mr. Smith?
Yes, Your Honor.
Mr. Malero, do you need to speak to Mr. Smith?
Yes, Judge, I was told that there's Mr. Smith wants to take a plea, and so I need to verify that with him and confirm that.
Okay. Okay, Mr. Rohrbeck, your attorney, Mr. Malero, is working with another client right now. As soon as he's done with that case, we will do yours.
Your Honor, I hired a different lawyer, Mr. Brian Fry, yesterday.
Okay.
So,
all right, we'll see if we can get in touch with his office.
Okay, thank you.
is file 25-22247-FH, People of the State of Michigan versus Dustin Wayne Smith. We are here today for a final pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
D.B. McClure, on behalf of the people.
Salvatore Malero on behalf of Dustin Smith.
And Mr. Miller, where do things stand with Mr. Smith's case today?
Your Honor, I did review the plea offer with Mr. Smith. It is acceptable with one alteration if Ms. McClure is okay with it. And that was that Mr. Smith would plead no contest as opposed to guilty. He did give me permission to sign it on that basis, and I can have that emailed to the court if the court wishes.
And Judge, I have no objection to that, and we can either use there was a preliminary exam in this case on April 29th, 2025, and I would have no objection to using the testimony from the exam to establish that factual basis, as long as there is a basis for the no contest plea.
Okay, Mr. Miller, what is the reason for the no contest?
Judge, I believe there could be an issue of civil liability here. Also, there's a pending matter in the family court that I believe would justify the no contest plea.
And I would agree with that then, Your Honor.
Okay. Has Mr. Smith signed an advice of rights form?
Not at the purpose of this plea. I'm sure he signed one in district court.
Okay.
If the jail can have him sign one, that'd be great.
Okay, Mr. Smith, we're going to have someone at the jail bring to you an advice of rights form and a pen to sign that. So,
could someone take an advice of rights pen to Dustin Smith?
When you get that, take whatever time you need to read it, and then if you're comfortable, sign it.
He's taking a plea. Yeah.
Okay, so Mr. Smith, if they bring that to you and you want me to stop at any point so you have time to read that, just let me know, all right?
Yes, sir.
Would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Dustin Wayne Smith, is that correct?
Yes, Your Honor.
Mr. Smith, you've heard the statement of your attorney and the prosecuting attorney.
Sign it. Comes back.
Hold on, Your Honor. Sorry about that.
Sure, no problem.
What was that, Your Honor?
Okay, have you had a chance to read that then?
I have read over it. Yes, I signed it.
And you signed it? Okay. Okay, Mr. Miller, I don't think you indicated that there was a plea agreement, but I don't think anyone has stated that for the record. So could you state the terms of that plea agreement for the record, please?
Yes, Judge. Judge, the plea agreement is the following: that Mr. Smith will plead no contest to count 2, accosting children for immoral purposes. There is no sentence agreement. Count 1 would be dismissed. Further, that Mr. Smith understands that this conviction will result in him being required to register under the Michigan Sex Offender Registration Act. And I believe that is the extent of the plea agreement that I reviewed with Mr. Smith. He said he understood it and gave me permission to sign that plea agreement.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Mr. Smith, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 2, accosting the child for immoral purposes?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $4,000 fine?
Yes, Your Honor.
Do you understand that this is a conviction that will require your registration under the Michigan Sex Offender Registration Act?
Yes, Your Honor.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Mr. Malero?
Yes, that's correct, Your Honor.
Is that also your understanding, Mr. Smith?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Smith, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I do, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about March 25th, 2025 in the city of Adrian, County of Lenawee, state of Michigan, you did commit the offense of accosting a child for immoral purposes?
No contest?
Yes.
Has anybody made any threats or promises to you, Mr. Smith, to induce you to plead no contest to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises closed to court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smith to plead no contests today?
No, Your Honor.
I am not aware
No,
of
Your
any,
Honor.
Judge.
Sorry, Judge, I apologize. No, Your Honor.
All right. Mr. Smith, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I understand, Your Honor.
Is it your own choice to plead no contest today?
Yes, it is, Your Honor.
And Ms. McClure, do you want to establish the factual basis with the use of the preliminary examination transcript then?
I would, thank you. So preliminary examination was held on April 29th, 2025 in front of, excuse me, in the district court of Lenawee County. And at that time, an individual who was, excuse me, had the initials ES, was 15 years old at the time, and is the biological daughter of the defendant, Mr. Smith. And her testimony included that in January of 2025, and in helping her remember it was January, they were celebrating Christmas late. So she knew it was January of 2025 when she was at Mr. Smith's house in the city of Adrian. I'm sorry, Your Honor. That her and Mr. Smith were watching a movie on his bed, and at the time Mr. Smith did lift her shirt up, and she had a V cut wire bra on, and when her shirt was lifted up, part of her breasts were exposed as well as her bra, and that Mr. Smith did grab her breasts and over the bra, but including some of her skin. And that was coupled with a comment. Her testimony indicated that the comment was, "If you weren't my daughter, I'd fuck you." And at that time, they finished watching their movie, and the individual who testified with the initials ES did leave the room and spoke with her stepsister about this incident. Let's see. I just want to double check the information. And Your Honor, I think the action coupled with the words in this case would satisfy the elements for accosting a child for an immoral purpose, and I would ask the court find as such.
All right, Mr. Malero, do you agree that that is an adequate factual basis for the no contest plea?
Yeah, I would have no objection to that description, Judge.
Okay. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Malero?
I believe the court has, yes.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Smith has had full knowledge of his rights. He has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for November 7th at 8:15 a.m. Mr. Smith, someone from the probation department will be in touch with you to do a pre-sentence investigation interview.
Thank you, Your Honor.
And Judge, two things. One, I would just ask that the trial obviously next week be vacated. I believe the victim in this matter may be appearing via Zoom for that sentencing just because they live some ways away. But if Mr. Smith is still in jail at the time, we just need to know if he wants to be in person or via Zoom.
So, Mr. Smith, you have a right to be present in person in the courtroom if you want to be. If you wanted to do it by Zoom, you would have to waive that right in order to do it by video conference. Do you happen to know right now what you would prefer?
I'm not honestly sure, Your Honor. I would
Okay.
prefer whatever my lawyer prefers.
Okay. Just stay in touch with Mr. Malero, let him know and what your decision is, at least a day or two, hopefully before the sentencing hearing, so we know what to do.
Thank you, Your Honor.
Thank you, Judge.
Okay, then you are all set for today, Mr. Smith. You can let the officer with you know that you're done with court.
Thank you, Your Honor.
You're welcome. And so, Mr. Malero, Mr. Rohrbach had indicated to me that he yesterday hired private attorney, Mr. Fry, to represent him. I don't think we have a substitution yet. I don't know if you may have received anything.
Let me look, Judge. I didn't see
Your Honor,
anything in the notes.
I thought this was due to the 10th. I thought we were gonna meet on the 10th. I didn't get no paperwork stating it was gonna be today. I got paperwork stating it was the 10th. I was gonna be in court. So it's, I haven't got, Mr. Malero hasn't got with me. He says go get with me last week to see what the prosecuting had offered or anything. I didn't hear from him. So last night, we got the number to this attorney. So they got called this morning to represent me. It was this morning. Your Honor.
Well, let's see here, Judge. My notes, I met with Mr. Rohrbach on the 25th to review the plea offer.
There was no offer as far as prosecuting what I was going to get.
Okay. All right. I appreciate
if we
that.
can adjourn a judge for new counsel, that's fine.
Thank you.
So what I'll do is adjourn this to next week. That's October 15th. So next Wednesday at 8:15, and we'll proceed with Mr. Fry representing Mr. Rohrbach, assuming that substitution gets filed.
Yep.
Thank you.
I'll do the step in order, Your Honor.
Thank you, Mr. Malero.
Thank you, Mr. Malero. Thank you, guys.
Yep, no problem.
All right. I believe that is everything for the criminal docket this morning.
Thank you.
Great. Thank you, Judge.
you.